Hello, happy Monday, and welcome to another video. You all remember Naziah Harris, right? And Jarvis Butts. Naziah Harris, who went missing, I believe in January of 2024. She was all around the internet with her aunts and grandmothers and all the family. Cousins, she still is all around the internet. But let me give you an update on the beautiful Naziah Harris. Naziah Harris went missing, yes, I was right, in January of 2024. The man who is charged with actually altering her and unaliving her at 13 years old, Jarvis Butts, has also been charged in other actual alt cases. Now that was to my surprise. He was in court today. She has been missing since January 9th. She's from Detroit. She would have been 14 now. I'm just going to talk about some things that they have found. Text records allege that Butts knew Harris was pregnant and that he began searching online about unaliving, CHILBABIES, ab pills, and drinking red antifreeze. Authorities believe Butts had been actually ab Harris since 2022 before unaliving her in January. Prosecutors said he had a history of targeting and befriending women to get close to and actually ab their daughters. Now, he was in court today for a pre-trial hearing. During the pre-trial hearing, the judge heard about discovery issues related to the cell phone, and let's get into it.
All right, good morning, everyone. We're calling cases 24-002-236, 24-006-232, 25-000-218, and lastly 25-000-241. These are all in the matters of People versus Jarvis Butts. I apologize, I believe I missed one. There's also file 25-004-478. Can I have appearances? Let's start with Pete possibly.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And good morning, Your Honor. Matthew Makepeace also on behalf of the people, P82796.
Defense.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Jarvis Butts, together with co-counsel Ken Riggins and Lauren Butler.
Good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125 on behalf of Mr. Jarvis Butts.
Good morning, Your Honor. Lauren Butler, P88126, also Neighborhood Defender Service on behalf of Mr. Butts.
Thank you. Mr. Butts is also joining us in court. Mr. Butts, your name, please.
Jarvis Butts.
All right, thank you. You can all have a seat. All right, attorneys, thank you for your patience this morning. We did have a relatively short chambers conversation about these cases this morning. And just to briefly summarize defense, you intend to raise an issue with regard to some outstanding discovery on the case ending in 218, which has the homicide charge. Is that accurate?
That's correct, Judge.
All right. It's also my understanding that there are two motions to quash filed today. The parties and the people submitted a written response to those motions to quash. I've had an opportunity to review them. Parties are ready to argue those motions today, correct?
We are, Your Honor.
Okay. Very good. All right, well, let's start with the file Mr. Butts is here to be arraigned on, that being the file ending in 4478. How does he wish to proceed for arraignment purposes?
Yeah. Mr. Butts would waive the formal reading of the information. He stands mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. A plea of not guilty will be entered on his behalf. Counsel, was the examination held in that matter?
It was.
All right, we're going to get that transcript ordered. And with that, do you want to move right into the respective motions to quash, or did you want to address the discovery issue?
I think we can go ahead and do the motions, and then we can discuss the discovery at the end.
Okay, very good. All right, who's going to take the lead from the defense?
Yeah.
Very good. Your motions.
Yeah, thank you. So, Your Honor, I did file a motion to quash relating to case ending in 6232. For the sake of privacy, I won't mention the complaining witness's name, but, Your Honor, there was a preliminary examination held in this matter. There was one witness called. The complaining witness, but the only witness called, she testified that at the time of the incident, she was 4 years old. At the time of the hearing, she was 13. So there had been a substantial passage of time. Your Honor, her testimony was she was home with Mr. Butts and Mr. Butts' girlfriend. At some point, the girlfriend left the bedroom. Mr. Butts was in the bedroom. She was on the couch. Mr. Butts summoned her to the bedroom, at which point she was ordered to take off her clothes. Her testimony was she took off all her clothes except her underwear. She took off her clothes, then Mr. Butts touched her. I believe the order of touching her was he touched the top of her thigh, then he touched under her breast. And then she said he touched her where she peed. Okay. That was the sole testimony of this witness. At the end of the proofs, prosecution moved to bind over on an original count of criminal sexual conduct in the second degree and added a count of criminal sexual conduct in the first degree because of the statement of because of the statement of complaining witness. Now, we believe that is an abuse of discretion. The only thing that we have on the record is she said she touched where she uses the restroom, and the only clarification we had was she said this is where she pees, or she urines from, excuse me, those were her words. From that, we have prosecution postulating that meant that there was some penetration, except there was no penetration mentioned. There was no penetration discussed. We know from case law, for a CSC1 to happen, there has to be some form of penetration, even the slightest. Case law also tells us if she testified that he were to force her underwear inside of her, that would be sufficient for penetration. Now, we don't have any of that. We never have conversation, or we never have any testimony about her panties being pulled aside. We never have any testimony about her panties being forced in her. We never have any testimony about anyone penetrating her. Now, that is, given the fact that she was 4 years old at the time this happened, granted. But at the time of the hearing, she was 13. Surely she could testify. I believe she was asked on direct that she remembered the events, and she said she remembered the events. None of that was testified. I think to say that there was sufficient evidence on the record that says that there was a penetration for the purpose of the CS1 is an abuse of discretion, and we believe that should be dismissed.
Thank you. And counsel, your respective motions, they're similar in nature in that you're arguing the issue of whether or not there's sufficient evidence on the issue of penetration on both your motions to quash, correct? Correct. Okay. Do you want to, why don't we have them argued as on the second matter, and then we'll hear one response from the people if you're okay with that?
That's fine.
Okay.
Okay, so this is then with regard to the case ending in 24101, and, sorry. Okay, and this is Lauren Butler, P88126 again.
Thank you.
So first, to overview the facts from that case, I want to emphasize that this is only with regard to one of the two instances described, the complainant described 2 instances, but only one of them has been charged as first degree. And I am only arguing in regard to that and that particular charge. So at the preliminary exam for that instance that was described, the testimony included wearing panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. The prosecution had the burden at the exam of establishing evidence of every element, and that included penetration. And again, the case law is clear on this. In particular, the case I cited in my motion, People v. McNeese, while that is unpublished, it is particularly relevant because it highlights this distinction where it needs to be more than just, it uses very similar language to that used in the exam here with this emphasis on touching the vagina, rubbing the vagina. That's not enough for penetration. And there was even a specified testimony about under the underwear and over, and yet even with that fact, the court still held that this was not penetration. And that's similar to what we have here, this description of some degree of touching in that area, but that alone is not penetration. It also relies on published case law, People v. Payne. Rubbing one hand, where it concludes that rubbing one hand over another vaginal area does not qualify as penetration. And I'd also like to address the response from the prosecution to this motion, because the argument they're making was not reflected in the preliminary exam testimony. Specifically, there was no testimony about inside the vagina. So while they're now arguing that that is possible, it's not the testimony we heard. We didn't hear this contrasting of the labia and the vagina. And this diagram that is now referenced in the motion was not used in the exam. So in conclusion, the prosecution did not meet the probable cause standard for first-degree criminal sexual conduct because there was no evidence of penetration, and bind over was not proper, specifically as to that charge.
Thank you. All right, who's going to take the lead from the people?
That's me, Judge.
All right, very good.
So I'll start with the first argument made by Mr. Riggins, the complaining witness there, whoever's by his initials, PB. She testified specifically that he touched my private part where I use the bathroom with. When asked what comes out, she stated urine. I then asked, tell me about what part of him touches you there. She states his hand. And what does he do? What does his hand do when he touches you there? She states he rubs my private part with his hands. I then clarified, is this on the top part of that? And she interjected, said the bottom. And I said, would that be where the pee comes out? She says, I clarified, is that a yes? So in summary, she testifies, she's rubbing the bottom part of her private part where the pee comes out. Your Honor, in a motion to quash, this is the highest deference to the reviewing magistrate in this case. It requires an abuse of discretion, which is most deference to the district court. Penetration requires any sort of intrusion, however slight. And we use the term genital opening rather than vagina, so that penetration of that labia majora is sufficient to establish penetration or criminal sexual conduct in the first degree. Here, the complaining witness testified that the defendant rubbed her on her bottom part where the pee comes out. When we think about basic anatomy, we know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there, but we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. So when this complaining witness testifies that he rubbed her bottom part where the pee comes out, she's referring to an internal structure, thereby penetration. The examining magistrate also found that, and so in her ruling, that for a woman to urinate, it's not on the outside of her labia. That's an internal, that would be beyond that. And so she found that it was a question of fact. I don't believe that there's any abuse of discretion by that. I believe that there's satisfactory testimony, at least to a probable cause standard, for that count. And do you want me to go on to the next one?
Please.
Okay. In the second case, extremely similar. This one is specifically, this complaining witness starts off by saying, you know how somebody would play with you in your sleep, like you would feel them in your ear, like this or something. We don't have what she was demonstrating, but she's playing with her ear. He was doing that to my vagina when I woke up and I was crying. She stated, or I said, all right, when you wake up to feeling something? She said, yes. I asked, where do you feel something at? She says, at my vagina. I said, what do you feel at your vagina? Should I feel like somebody's playing with me? Like, I don't know, like somebody's trying to touch you but not wake you up while he's touching you. And I said, what part of him is touching him? I'm touching you. She said, he's using his hands. She later confronted the defendant about it. He's asked her why I was acting so weird towards him. She said, you don't remember what you did to me? He, the defendant, looked me dead in the face and said, I don't remember doing that, but if I did do it, then I'm sorry. Again, the reviewing standard is abuse of discretion. And here, similarly, she testified that she felt the defendant at her vagina, that she felt the defendant playing with her, using his hands at her vagina. It's more than just mere contact, mere brushing against the vagina, or just merely touching on top of it. It's an intentional act at her vagina. By stating she felt the defendant's hand at her vagina, she's testifying to penetration. She did not state that she felt his hand on or over her vagina, but rather at her vagina. Again, we look at basic anatomy, Judge. The vaginal opening is beyond beyond or inside both the labia majora and the labia minora. And so because sexual penetration is defined as the labia majora and beyond, the vaginal opening is beyond both the labia majora and minora. And so by stating that she felt the defendant's hands at her vagina playing with her, she testified to penetration. And I believe that there is satisfactory testimony on the record to satisfy that to the probable cause standard, which is, again, probable cause standard is the lowest standard, and abuse of discretion is the highest deference to the examining magistrate. And I believe that they both create questions of fact.
Thank you. Your defense, wish to respond?
Your Honor, in all seriousness, we're giving far more biology of the human anatomy than was ever put on the record at the preliminary examination. All we had at the preliminary examination, they were touched at the area. We have young ladies who, although at the time this happened, may have been too young to describe the actual part. At the time of the preliminary examination, surely they could have said, he touched me on the inside. He forced my panties aside. He touched me on the inside. And in either case, was that testimony ascertained, that testimony was given, that question was asked by either people. So here, all we have is hyperbole. This is what the complaining witnesses must have meant when they said that. Yeah, and I think that is a far reach, and I think surely that is an abuse of discretion to just simply say they must have meant there was internal penetration. That is an element the prosecution has to prove in each and every case when they charge a CSC in the first degree. In neither case was that proven, was that ascertained. We just have speculation, and to put those charges in front of a jury would simply be wrong, Your Honor. So we're asking you to deny to grant both motions to quash.
Thank you. Your response?
Judge, I would just reiterate what he is already saying. I think in my case in particular, there's this emphasis on the word at. There's just it's not realistic to say that that's what at means. This comparison between at and over is really not what plain meaning tells us about the word at. At is very different from inside, all of what Mr. Riggins really just emphasized. So again, I would object that this should be dismissed today.
All right, thank you. All right, well, a motion to quash, and there's two motions to quash that have been filed by defendants. So the court has to review the record for an abuse of discretion, which has already been pointed out. The abuse of discretion standard is a high burden. And defense here, through their written and oral arguments today, have challenged the sufficiency of the evidence presented on the bind-over of the respective counts of criminal sexual conduct in the first degree regarding the issue of penetration. So the court has had an opportunity to listen to the respective arguments from the attorneys here today. I've also had an opportunity to review the lower court record and namely the transcripts. And of course, the prosecution at the preliminary examination has the burden to show competent evidence that probable cause exists on each of the elements of the charged offenses. So here, looking at pertinent portions of the transcript, and I'll start with the case where he is the alleged complainant. There's a few pertinent portions of that examination transcript, starting on page 58. And it notes, line 20, her answer to a question, he touched my private part where I used the bathroom. Question, okay, and when you use the bathroom, what comes out? Answer, urine. Question, urine, okay, tell me about what part of him touches you there. Answer, his hand. Question, on the following page, okay, what does his hand do when he touches you there? Answer, he rubs my private part with his hands. Question, okay, was this, so when he's rubbing your private part with his hands, is this on the top part? Answer, the bottom. Question, the bottom part, okay? Answer, yes. Question, okay, and is that would be where the pee comes out? Answer, yes. With regard to the file where the alleged complainant is AD, I'm directing the attorney's attention to the pertinent portion of the testimony on this issue of penetration, page 83, line 14. This would be multiple paragraphs into her respective answer, reading, and you know how you like how somebody would play with you in your sleep, like you would feel them. And I think the pertinent part of this answer that's relevant to this determination is the next three words. And again, it's like you would feel them, quote, in your ear, like this or something. He was doing that to my vagina when I woke up and I was crying. Moving to the next page, page 84. Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad? Answer, yes. Moving to page 85, line 8, question, all right, and when you wake up, you kind of wake up to feeling something. Answer, yes. And where do you feel something at? Answer, my vagina. Question, what is it that you feel at your vagina? Answer, I feel like somebody playing with me. Like, I don't know, like somebody like trying to touch you, but trying not to wake you up while he's touching you. Question, okay, and do you know what part of him he is using to touch you? Answer, he's using his hands. So sexual penetration is defined, and that's defined under 75052-0AR, sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any part of a person's body or of any object into the genital or anal openings of another person's body. But emission of semen is not required. And here, based upon my review of the lower court's record and testimony utilized in making the final decision, I think based upon the testimony that I just read in the record verbatim, the examining judge did not use her expression in binding over respective counts of criminal sexual conduct in the first degree. I think that there was sufficient evidence presented on each of the elements, and specifically the element of penetration in both files, to uphold the bind over, and attorneys are going to respectfully deny the motion to quash. All right. So attorneys, we have a couple of other issues to discuss. In defense, would you like to get into the discovery issue that
Sure.
noted earlier?
So one of the largest pieces of evidence is the CSLI that was used at the preliminary examination, which the prosecutor posits puts Mr. Butts at the scene of where certain pieces of evidence were located.
And so we're clear, counsel, you are moving into the file ending 218, correct?
Yes.
Okay, thank you.
Apologize, thank
That's
you.
okay.
Back on February the 6th, Mr. Riggins reached out to the people and alerted them that our expert to review what we needed was the Cellbrite UFED, basically the underlying data that is pulled, not the report that is generated from Cellbrite.
What was the date that was put on notice?
February 6th.
February 6th. Okay, so just about 6 months ago.
Correct.
Okay.
And then we received a response back on the 14th from the people saying that they would work on it and get back to us. We received another response on the 28th that they were looking for the files, essentially discussing that it's a huge amount of data that has to be transferred. And then we followed up, it was sometime later. And the next response I have is from May 28th, that there would be a follow-up with the right person at DPD. They would get back to us. So we've been in communication with the people about this for this entire time. There's no surprise that we've been asking for it. And the response has generally been either that the DPD has it and they're working on transferring it, or that it's taking a really long time to do because the data is so great. They have to basically go through three different, they would take it from a hard drive onto another thing that can be transferred, put it on ours, and then they can send it to us. And as of this morning, we still don't have it. We are less than 2 months out now from trial, and given this is a huge amount of data, we have to have our expert look at it. We are very concerned that we don't have it yet.
Understood. So we do have trial set in that file. I've got it set for October 6th, so we're just north of 2 months by my math. So Mr. Makepeace, did you wish to respond from the people's perspective? Why has this taken so long when it was put on your notice 6 months ago?
Yes, Judge, no, I'm not disputing the dates or the emails that Ms. Quick referenced and the responses. There was a period of time where we had kind of, because it is an unusual request for the underlying file, they do, for the record, are in receipt of the cell phone forensic extraction reports that are generated, which are the files that are usually turned over. Those are UFDR files. This is the underlying file that comes with that or is generated and then put into a report. They have requested that on the dates and times. There was a period of time where I had to communicate with the OIC as well as the cell phone expert at DPD to figure out exactly what they were asking for. That did take some time, and then there was a period of time where I requested from the defense a hard drive that they provided to us for these to be uploaded onto. That hard drive, and I don't have the exact date in front of me, was turned over by Mr. Riggins to me. I transported that hard drive to the Detroit Police Department and provided that to the officer in charge of the case, as well as with the understanding that she and the cell phone expert would get together and get this uploaded. That's where I think the biggest delay comes from, is that there was a little bit of a miscommunication to them, between them, on our side of it, which is that one said it was done, one said that the other person did it, and nobody actually ended up doing it. When I went back to pick it up, it wasn't done. At that time, I brought the hard drive back to DPD and said, this needs to be done as quickly as possible. That was within the last month or so. The actual process for them to upload these or get the files onto the hard drive is to take it from a Blu-ray disc or a DVD onto the computer and then onto the hard drive itself. That does take some time, given that there are, I think, 15 or so phone dumps that they've requested these files for, and the amount of information is large. As of this morning, I spoke with the cell phone expert who is in the process of doing this. He states that it will be done middle of this week, Wednesday. And at which point I will myself go to DPD, gather the hard drive, and provide it directly to Mr. Riggins or Ms. Quick or Ms. Butler.
Okay, so you believe you will have it to them by the 6th?
Yes.
Okay, which is exactly 2 months out from our trial date. All right, why don't we schedule an additional pre-trial date for all files and bring it in to hash out any potential trial issues and things of that nature. Also noting the people did file a notice of other acts. Which files did you file?
Judge, I filed that on all of the cases except for the newest one, because that one wasn't in the system yet. So yes, there should have been 4 filed as of last week.
Okay.
And we do intend to file an objection.
Yes, Your Honor.
All right, very good. So why don't we schedule a date to hear that? Are you anticipating filing a notice on the case Mr. Butts was arraigned on today?
Yes.
Yes.
Okay, all right. Defense, how much time do you want to respond?
2 weeks.
Okay.
I apologize, Mr. Reigns is out of the office for one of those next 2 weeks, so if we get it free.
Why don't you come back on Friday, September 5th?
Judge, I'm off that day. Back next Monday, though.
Is this something, Mr. Ripley, that you would be able to handle in Mr. McPeace's absence? If not, I can find another date.
It is, Judge, but I'm going to be in a 2-defendant homicide trial that starts on the 2nd. And it's in Judge Cusick, so I anticipate it going on Friday.
Okay, understood. What if we come back on Friday, September 12th, mid-morning?
If we could come after my exam, that would be good for me.
The 12th is not a good day.
12th is not a good day.
I could do the 11th. That was good.
Strictly on the 11th?
I'm going to be at that 2-defendant homicide. I said the 15th or the 16th. I know that's cutting close. You're starting to cut close, but
I think we could do
How about Tuesday the 16th? Does that work for everyone's calendars?
Seems to work.
yep, that works.
Right. Okay. We'll come back Tuesday, September 16th to listen to argument on the other acts notice that the people have filed. Let's set that hearing at 10 a.m. All right. Were there any additional issues that needed to be talked about or addressed from the people's perspective for today?
Judge, no additional issues. As I would in any case, I would just place on the record an invitation for defense counsel to come to our office to go through both paper and digital files to make sure that there are no other surprises. Just place that on the record. Ms. Quick, Mr. Reagans can communicate with me to set that up.
Absolutely. And as noted in chambers, when we set our October trial date, it was far off into the future. It was far off into the future with the, of course, the intent that all parties would make sure that they're doing everything possible to make sure that this case, or case is trial ready for October the 6th. So, at this point, we've got our trial date, October 6th, and we'll see you for pre-trial date, again, Tuesday, September 6th at 10. Were there additional issues that defense needed to address for today's record?
I don't believe so, Your Honor.
All right, very good. I thank you all for your time and patience today. That will conclude our record.
Thank you.
Thank you. Thank you.
So as of now, we are updated, and they will be back in court for pretrial September 16th, 2025. Jarvis Butthead trial starts in October. Let me remind you that Naziah Harris's body has never been found. Let me know your thoughts and opinions on this case, as I will do my best to stay on top of this. Don't forget to like, share this video, again, comment, and please subscribe. Don't forget to subscribe and hit the notification bell so whenever I upload or go live, which I will probably go live in about an hour, you will get the ring, or you should get a notification in your email. Thank you all for listening. Let's keep Naziah and her family in our prayers. And Jarvis Butthead, you going to jail. You going to jail. I've been waiting for this day. You going to jail, and I'm going to record every day of your simple in court.